That just makes sense. If you can do all of this while avoiding probate, then it's worth doing a revocable living trust. Hi, Jeff Marsanti, the Plain English Attorney, and today we're going to react to something on r/estate planning about testamentary trusts. Now, a testamentary trust is a trust that is formed under a will. I've even heard it called just trust under will. What this means is probate, and a lot of my clients, they come to me because they want to avoid that. So let's go ahead, we'll jump right into seeing exactly what the questions are. Well, you know what? Before we actually go in there, please go ahead and click like on the video. If you think it's important to get information like this out there, that's the best metric, is to click. And if you like these videos, please subscribe to the channel. It really helps us out. So let's go ahead and jump into it. Testamentary trust. Hey all, I was wondering if you could help me understand more about testamentary trusts. I appreciate your help. Does a testamentary trust have separate paperwork/documents relating to beneficiaries, etc., or is that all typically laid out in a will? Next question is, what powers does a trustee typically have? And what happens when a beneficiary of a trust dies? Can they pass on their share to descendants? For example, I am a beneficiary of 1/3 a trust. Can I pass that to my spouse or child if I were to pass away? Thank you. All right, some very good, very basic questions about a testamentary trust. Let's go ahead and see what the other members of the community, mostly our attorneys, and I see them in a lot of different ones, and I will end up putting in my comments at the end. Local, meaning state law, will specify some powers and restrictions that a trust must impose on the trustee. Then there are a lot of powers and restrictions that are defaults unless the trust terms say otherwise. Very true. And from Dingbat, unless it's a special needs trust, a testamentary trust is the hallmark of a crappy lawyer. Now to answer your questions. A testamentary trust is typically laid out in the will, often very sparsely, but it can be in great detail. The terms could be attached to the will as an appendix. It is not a separate document. The powers of the trustee are generally described by state law, though the written documentation can modify that. Typically, handle the assets prudently and for the benefit of the beneficiaries. What happens when the beneficiary dies should be spelled out in the will. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. All right, so kind of straightforward, but also with criticism for attorneys that do a testamentary trust under a will. I'm going to address that in a little bit. A testamentary trust is the exact same as an inter vivos trust, except that it comes into being upon your death as opposed to coming alive during your lifetime. Okay, one of the reasons I'm called the Plain English Attorney is I don't use the terms like inter vivos. It's a living trust. A testamentary trust, just like an inter vivos trust, may come into being simply by transferring some property to a trustee with words such as, I am entrusting you with this piece of property to hold for the benefit of my daughter Susan. Upon reaching 21 years of age, you are to convey the remainder to her outright. As such, the testamentary trust can be as complex or as simple as you'd like. The only difference is that the document itself is your will. Okay, that middle paragraph was kind of textbook law school. What is a trust? Thing is, a trust doesn't even have to be in writing. It's just, okay, good luck trying to prove that if a question ever comes up about it, which is why when you're talking about trusts, we're talking about something that's in writing. that describes it, because anyone can say, oh, well, that's not what they said to me. So let's keep going because I'm going to address a lot of this at the end. And from Exton Guy, the terms are typically laid out in a will. In my honest opinion, it's better to use a separate document and have the will pour over to the trust. Now, I'm going to clarify that this is basically, it's a revocable living trust along with the pour over will. The trustee has all the powers defined by the trust statement and local law. Sometimes these are very broad, even to the point of selecting the beneficiaries. Sometimes the powers are very restrictive, defining specific investments and payout schedules. The trust terms define what happens when a beneficiary dies. Or if the terms are silent, then local law is used. Sometimes the terms allow the beneficiary to specify in the beneficiary's own will. More commonly, the terms say that the beneficiary's children get his share no matter what the beneficiary might have wanted. Okay. So that's an awful lot being said in those few sentences. Yeah, local law does fill in a lot, and I'm going to comment on that in a bit. And it's not generally what you want. If you're the beneficiary, it's not, oh, well, when I die, I want this to go here. That's not usually the case, although it can be. Most of the time, it's spelled out right in the document itself, whether it's a testamentary trust under the will or it's a revocable living trust. It's kind of spelled out who the contingent beneficiaries are. All right. A pour over will pours over into an existing inter vivos or living trust, not a testamentary one. Okay, very technical. We kind of knew what Exton Guy was talking about. And then quoting, in my honest opinion, it's better to use a separate document and have the will pour over to the trust. The other alternative is a pour over will that goes into a testamentary trust created per the provisions in an inter vivos revocable trust, right? What would the advantage be of having a separate testamentary trust other than the one created via the inter vivos trust upon death? I'm not following this one. The will plus separate testamentary trust would be more private than having the trust provisions in the will, but are there any other advantages? That was really kind of confusing considering the question, and it's like, okay, well, you can have a will pour the assets over into another trust that's generated by the will? No, it's not making sense. All right, let's go back and see. Privacy is the main advantage. It also helps to focus on the benefits of having a living trust funded before death. All right, yeah, we're talking about revocable living trusts. Quoting, in a testamentary trust created per the provisions in an inter vivos / revocable trust. Technically, that would be, quote, in further trust, or a trust created by a trust. A testamentary trust is created under a testament, a.k.a. a will. All right, splitting hairs, but very true. It makes a lot more sense to have a revocable trust that remains in existence after death or that creates new trusts upon the grantor's death because that avoids probate. Big props for that. Yes, probate is what happens when you have a will. With exceptions, the only reason for a testamentary trust is a testamentary special needs trust. Other than that, a trust created by a revocable trust is superior in every way, including cost. Now, that's cost overall. The fact is, probate generally eats up somewhere between 4 and 10% of an estate. And I mean, it's highly dependent on what assets are in there and how many assets are in the estate and what else is complicated about it. But it can end up, in the long run, costing a lot more to do a will, which is usually less expensive to set up than a revocable living trust. So, yeah, we're talking long-term costs here. So that is a big factor. So let's continue. And now we're getting to my advice A testamentary trust is basically language written into a last will and testament that holds and manages estate assets for a beneficiary over a period of time beyond the probate estate being initially settled. Unfortunately, this has a lot of drawbacks depending on state law. A testamentary trust may mean that the beneficiary share has to be supervised and overseen by a court until all of the money has been distributed. Okay. So if a 5-year-old grandchild gets an inheritance through a will to be held in trust until they turn 25, could mean 20 years of reporting to a court. Most of my clients come to me because they want to avoid the probate settlement process by using a revocable living trust, so they often see even less value in setting up a testamentary trust where reporting to a court could drag on for decades. That's a huge point that nobody had really made yet. It's that depending on your state law, that testamentary trust could have to be overseen and have all of the reporting and the assets continue to go to the probate court year after year after year after year, all to save a little bit on the front end. It often doesn't make sense if you have trustees that you trust to handle things. Now, they mentioned a special needs testamentary trust. There might be some specific kind of saving provisions in state law, but generally speaking, if it can stay out of probate, keep it out of probate. So let's continue on. When it comes to who gets the share after a beneficiary of a testamentary trust passes on, that is done according to the terms of the will/testamentary trust. Often the person whose will it is specifies contingent beneficiaries. For example, it is extremely common for trusts that leave a share to their child to direct that if all the assets aren't distributed before the beneficiary, meaning the child, dies, that it would go to the child's descendants and not their spouse, even though most people would designate their own spouse as the primary beneficiary in their own plans. Sorry to all the sons-in-law and daughters-in-law out there, but most people care more about their own child and grandchildren far more than you. But that's okay, because your parents often care more about you and your children than your spouse. So here we're talking about who would be these typical contingent beneficiaries, and very often it's drafted right in there, at least if it's kind of done correctly, at least one level past what happens if they die. Now, sometimes there can be 2 or 3 or 4 or more levels of contingencies, and in my practice, I try to go at least a couple of layers in, but sometimes it's silent. And the point was made previously, what if it doesn't say? Well, then that's when you end up going to state law to see who those beneficiaries are. Now, one thing I'm just going to make a comment on the specific terms and powers and stuff like that. State law covers all of these different contingencies, and there are cases to fill in the gaps, and it's just this whole big expansive thing. Well, going back about 10 years ago now, probably even more than that, I attended a kind of day-long CLE, and it was almost 2 hours and 45 minutes on, I think it was the 187 updates to trust law. 185 of them were, well, if the document doesn't say, then here's what you do. Why not just put it in the trust? That just makes sense. So that was one of the last times I kind of went and attended an on-site CLE. I end up getting most of my required credit hours through teaching, and then for stuff like ethics and, believe it or not, there's a substance abuse for attorneys thing that you have to take. I take that stuff online. I'm not going to sit through almost 3 hours of, well, but the document if the document doesn't say, then here's what it is, and it's, no, just make the document say it. So when I checked, that 185 things were already in the documents. Those other 2 things were related to like tax credits for fisheries or, some other such very, very, very specific thing that's not likely to come across. And if so, all right, what was in state law seemed okay to me. So let's continue. As for powers of a trustee, these can be drafted into the testamentary trust, but state law is often the foundation. Basically, the way to think about it is state law will dictate all of the different powers that a trustee has and all of the powers they are denied by default. But there are a lot of terms, but not all, that you can customize. This is why you may see a lot of testamentary trusts that have very few actual provisions related to trustee powers, because state law will fill in the gaps, or really fill in most of it. I'm going to disagree a bit with Dingbat about a testamentary trust being the hallmark of a crappy lawyer, in that I and a lot of other attorneys do draft wills for clients after an education process that lays out the pros and cons of probate and how a revocable living trust works to avoid it. The fact is that drafting wills is a lot less expensive than a revocable living trust and accompanying documents. However, if after that education process my clients come to the considered decision to still use wills, then that's their choice. I would absolutely agree, though, that a lawyer that doesn't counsel their clients on revocable living trusts as an alternative to wills is falling down on the job. Another point is that if the client starts wanting to customize the terms of the testamentary trust to the point that at an hourly rate, the cost of the will starts to look similar to a revocable living trust, then why not just do the trust and avoid probate at the same time? That just makes sense. If you can do all of this while avoiding probate, then it's worth doing a revocable living trust if you're just going to spend a ton of money trying to customize a will with all of these special provisions. Just go ahead and do the revocable trust. I know the templates that we use for a simple will, even one with just small language about a testamentary trust or an age limit, all of what we really need is in the templates that we start with when it comes to a revocable living trust. All right, so let's keep going. And we're closing this out. I hope that helps. If you are still doing research on this for your own plans, I would recommend looking into a revocable living trust as a better alternative to a last will and testament with testamentary trust provisions. So really, avoiding probate can be one of the hallmarks of a revocable living trust that you're not going to get with a testamentary trust. So really digging into, well, what if we have a testamentary trust? Not only does it mean probate, to settle everything and get it through, okay, all your bills are paid, taxes paid, all this stuff is done, everything's divided. Now it's going to sit under a court's jurisdiction for 20, 30 years for a young beneficiary? Why would you do that? Don't do that. Look instead at a revocable living trust. Now, a couple of resources that are out there. Still one of the best books that are out there, even though at this point, the tax numbers are wildly outdated. If you don't look at the numbers and you just look at the concepts, The Living Trust by Henry W. Apps III. It's a nice, thick, 400 or so plus page book. It's going to have a lot about revocable living trusts. I did a much shorter version, being the plain English attorney, just trying to get to the point, called Estate Planning Basics, and we even have an audio book for that. There will be links in the description below. So, yeah, definitely, if you're talking about a testamentary trust, you really should be looking at a revocable living trust as the alternative because of all the advantages that it has. So, I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.